Have you ever found yourself wondering about the complex, often unseen factors that shape decisions in the biggest institutions of our society? How do they navigate fairness, ambition, and, well, the bedrock of our law?
It's truly a high-stakes balancing act, isn't it? Where constitutional principles, generations old, meet these really urgent demands of building a dynamic, diverse future.
That's precisely the kind of intricate challenge we're diving into today here on The Deep Dive. We're plunging headfirst into the often debated world of race-conscious public university admissions policies, specifically how they line up, or don't, with the 14th Amendment.
Right. And our focus today is a really crucial Supreme Court case that kind of brought all these tensions to a head. Fisher v. University of Texas at Austin II.
We'll be navigating the majority opinion delivered by Justice Anthony Kennedy and also the powerful dissenting opinion from Justice Samuel Alito.
And by the end of our conversation, you'll be able to articulate the core legal reasoning behind these policies. You'll get how prior Supreme Court decisions sort of carved out this complex legal landscape.
And distinguish between the compelling arguments made both for and against these programs.
Think of it as a shortcut, maybe, to being truly well-informed on a topic that continues to shape higher education.
All right, let's peel back the layers then. Let's understand what brought us to Fisher II. To really grasp the significance of Fisher II, we need to rewind a bit, understand the foundation. At its core, this whole debate hinges on one monumental idea from the Constitution: the 14th Amendment's Equal Protection Clause.
Simply put, it says states can't play favorites, right? They can't deny any person within their jurisdiction the equal protection of the laws.
And that's the ultimate legal lens. It's how all these race-conscious policies get scrutinized.
And what's truly remarkable is how the Supreme Court has grappled with applying that principle in higher education over, decades. These aren't just case names. They're like chapters in the court's long, often evolving effort to figure out where race fits into a truly fair admissions process.
Yeah, each one lays a new brick in the past leading us to Fisher.
Exactly. It's like a continuous conversation the court has been having.
Okay, take Regents of the University of California v. Bake back in 1978. That case famously said no quotas.
Right.
Universities couldn't set aside a specific number of spots just for minority applicants.
But crucially, it also established that race could be taken into account as one factor among many in admissions.
So the court was essentially sending kind of mixed signals then, leaving universities to interpret these very fine lines themselves.
Exactly. Bake was deeply fractured. It was a compromise that left a lot of ambiguity. It told universities, you can consider race, but don't draw hard lines.
Which led to a lot of experimentation, I guess, and eventually more cases trying to bring clarity.
That's where the two University of Michigan cases from 2003 come in.
Ah, yes. Gratz v. Bollinger and Grutter v. Bollinger.
Yeah.
Decided on the same day, but with really different outcomes.
Mm-hmm.
In Gratz, the court struck down Michigan's undergraduate system. It used this mechanistic points-based system. If you're from an underrepresented minority group, boom, 20 automatic points.
But in Grutter, the court upheld the University of Michigan Law School's holistic review process. There, race was just one factor among many.
So what was the court really grappling with here? What made one system okay and the other not? Was it just presentation or something deeper about fairness?
That's a crucial distinction, and it really goes to the heart of the matter. The court isn't just splitting hairs here, it's drawing a fundamental line. Race can be a thread, in the rich tapestry of an applicant's story during a holistic review.
Okay.
But it can never be the preset score quota you chase, a mechanical plus factor, like in Gratz, that reduces an individual to just a racial category, grants an automatic benefit.
Right.
But in Grutter, race was considered as part of a student's unique background, how their experiences shape their perspective and how that perspective would enrich the classroom. It's about respecting individual narratives over, numerical checkboxes.
That's a great way to put it, respecting individual narratives. Okay. So with this delicate balancing act in mind, how did Texas, specifically UT Austin, navigate these complex waters before Abigail Fisher's case even landed?
Well, Texas had its own unique challenge. Back in 1996, a Fifth Circuit decision, Hopwood v. Texas, actually invalidated UT's race-conscious admissions program entirely.
Wow, entirely.
Yeah, that decision had a significant chilling effect. It essentially told Texas universities they couldn't consider race at all in admissions. It forced UT to, completely overhaul its approach to diversity.
And UT's response to Hopwood was pretty innovative, wasn't it?
Yeah.
Just a year later, 1998, they implemented what's known as the Top 10% Plan.
Right. Automatically grants admission to students who graduate in the top 10% of their Texas high school class.
It was designed as a race-neutral way to achieve diversity after Hopwood, yeah.
Exactly. A clever workaround. Designed to bring in a diverse student body based on academic merit within individual high schools across Texas, rather than directly using race.
But what about applicants not in that top 10%?
Right. For them, UT developed a holistic review process. This was a really comprehensive assessment looking at everything: essays, leadership, extracurriculars, community service.
And they have these indices, right?
Yeah.
Personal Achievement Index, or PAI,
Yeah.
and an Academic Index, or AI.
Mhm.
And within this holistic review, race was considered as one factor among many.
So let me make sure I understand this. The AI and PAI themselves, they didn't explicitly consider race.
Correct.
But the overall holistic review, taking those indices and everything else into account, did allow race to be considered as a, quote, positive feature.
Yeah.
What's the practical difference for an applicant between that and the mechanical plus factor that got struck down in grads? It sounds kind of similar.
It's subtle, yeah, but it's a critical difference the court has consistently emphasized. Imagine it this way. A mechanical plus factor is like getting, say, 50 automatic bonus points just for checking a box for your race, regardless of your individual story. That's grads.
In a holistic review, like UT's, an admissions officer might read an essay where a student describes unique experiences shaped by their racial background, and they understand how that perspective would enrich the university community. It's not an automatic plus, but an integrated contextual part of their overall story. It contributes to the full picture of who they are. It requires, like, individualized consideration, not just a tally mark.
That definitely helps clarify it. Okay. Now, into this complex and evolving legal landscape stepped Abigail Fisher. Her personal story would bring these constitutional questions right back to the Supreme Court's doorstep, forcing them to refine their answers once again.
That's right. Abigail Fisher, a white applicant, wasn't in the top 10% of her high school class, so no automatic admission to UT Austin in 2008.
And she was denied admission through that holistic review process we just discussed, so she sued. Argued UT's use of race violated the Equal Protection Clause.
And her journey to the Supreme Court was, well, quite a trek. It took years. The District Court and the Fifth Circuit Court of Appeals initially upheld UT's policy.
And they used this term deference, right? It was almost like they were saying, hey, the university knows its business best. We'll trust their judgment.
Pretty much. But the Supreme Court, in that first round, Fisher I basically said, hold on. When fundamental rights like equal protection are at stake, we need to scrutinize every detail ourselves, not just nod along.
Exactly. So in 2013, Fisher I vacated that Fifth Circuit judgment, told the lower courts they'd applied too much deference. The Supreme Court demanded a rigorous, strict scrutiny review. You got to think of strict scrutiny as like the legal system's absolute highest bar jump.
It really is.
To clear it, UT had to prove two things with incredible precision. First, an unavoidable, absolutely essential reason, that's the compelling governmental interest to consider race. And second, that their method was the only, most precise way to achieve that goal, like using a surgeon's scalpel, not a sledgehammer that's narrowly tailored.
It's an incredibly high bar.
So after this remand, the Fifth Circuit reviewed the case again under that newly emphasized strict scrutiny standard. And what happened?
Well, once more, they affirmed UT's admissions policy.
Again, okay.
Which, of course, led to the second appeal back at the Supreme Court. And that brings us right to Fisher v. University of Texas at Austin II in 2016. After years of legal back and forth, the stakes for affirmative action higher than ever, the moment of truth finally arrived.
And so the big decision. Justice Kennedy, writing for the 4-3 majority, affirmed the Fifth Circuit's judgment. The court found that UT's race-conscious admissions program was constitutional. It passed that demanding strict scrutiny test.
Right. To satisfy that first part, the compelling governmental interest prong, Justice Kennedy's opinion really emphasized UT's goal of achieving the educational benefits of diversity.
And this wasn't just about optics, right?
Sure.
Or meeting quotas.
No, not at all. It was about promoting cross-racial understanding, breaking down stereotypes, genuinely enriching classroom discussions, preparing students for a diverse workforce and society. The university, the court said, had demonstrated a reasoned, principled explanation for how diversity materially contributes to its educational mission.
So it wasn't enough to just want diversity. They had to show it was like an absolute non-negotiable core part of their educational mission.
Exactly, an educational necessity.
When Justice Kennedy talks about that reasoned, principled explanation, How exactly does a university prove that?
Mm.
Especially under such a high legal standard.
Yeah, it's not easy. UT provided a ton of evidence studies, reports, testimony from faculty, administrators, all explaining why a diverse student body was critical to their academic environment. They detailed how diverse perspectives enrich classroom dialogue, prepare students for a multicultural society, a global economy, challenge preconceived notions. It wasn't just some vague aspiration, it was a deeply integrated educational philosophy, backed by their own assessment.
That makes sense. Now let's dive into the narrow tailoring part. That seems even trickier. The court noted UT's policy considered race as just one factor among many in that holistic, individualized review. Never the determining factor, never a quota.
That distinction, hammered home in Grutter, remained absolutely vital.
And what about the top 10% plan? Did the court address that?
Oh, definitely. The court acknowledged UT's significant efforts to achieve diversity through race-neutral means, especially the top 10% plan. However, the majority found that the top 10% plan alone was insufficient to achieve what they called a critical mass of diversity.
Critical mass. What does that mean exactly?
It's the idea that you need enough diversity for it to actually have those educational benefits. It's not just about meeting some number. It's the court acknowledging that diversity isn't truly impactful if it's just, tokenistic. You need enough diverse voices at the table to genuinely shift perspectives, challenge assumptions, really enrich the learning environment.
Okay, so the top 10% plan brought in diversity, but not enough for that critical mass.
That was UT's argument, and the majority accepted it. They also gave weight to UT's good faith efforts, continuously reviewing and adjusting its policies to try and comply with legal standards.
So if the top 10% plan already brought in substantial diversity, why was it still deemed insufficient for UT's goals? What exactly was the gap it couldn't fill? That seems like the million-dollar question.
That's a really perceptive question, and it was totally central to the debate. The top 10% plan, yeah, it effectively ensured racial and socioeconomic diversity within the top tiers of individual high schools across Texas. Very effective in that way.
Okay.
But UT argued it didn't necessarily bring in the specific types of diversity or a sufficient number of students from certain backgrounds to foster the deep, cross-cultural learning environment they envisioned. For example, it might not bring in enough students from, say, highly competitive, predominantly white high schoolers who might not be in the top 10%, but whose backgrounds could still contribute significantly to diversity goals.
Okay.
And it also didn't guarantee a critical mass of students with diverse viewpoints within specific academic programs or classrooms. It was a bit blunt, maybe.
Right. So for the majority, Justice Kennedy's opinion essentially confirmed that UT's system, this combination of top 10 and holistic review with race as a factor, was okay. It was an appropriate, limited use of race to achieve a permissible educational goal, meeting that incredibly demanding standard of strict scrutiny. Kind of reaffirmed Grutter then.
Precisely. It was a careful balance, acknowledging both the constitutional command of equal protection and what the court saw as the compelling educational mission of universities seeking diverse student bodies.
Of course, not everyone on the court saw it that way. Justice Alito, in his powerful dissent, argued UT's program was flat-out unconstitutional, believed it utterly failed strict scrutiny. He clearly felt the majority was letting UT off too easy. How did he interpret the very same facts so differently?
It's a fascinating tension, isn't it? Highlights a deep philosophical divide. His critique of the compelling interest was really pointed. Alito contended UT just failed to demonstrate that its race-conscious policy was actually necessary to achieve its stated diversity goals.
You questioned the evidence.
Yeah, he questioned the tangible evidence of those educational benefits of diversity, argued the university didn't clearly define or even measure the critical mass it was aiming for. From his perspective, the top 10% plan already brought substantial racial diversity to UT. He suggested the extra race-conscious measures just weren't truly needed.
And what about narrow tailoring? Was he critical there too?
Equally critical, Alito argued UT hadn't adequately proven that race-neutral alternatives, mainly the top 10 plan, were insufficient. He saw that plan as a very effective race-neutral measure.
He thought it was enough on its own.
Essentially, yes.
Right.
And he felt that for some students, particularly those outside the top 10%, race was becoming a determinative factor, functioning as that impermissible plus. He worried this stigmatized beneficiaries and actually contributed to racial balkanization, increased separation rather than integration.
That's a strong charge.
It is. This point truly highlights Alito's core disagreement. For him, UT's justifications for using race were just too vague, too unconvincing. They failed the rigorous standards, strict scrutiny demands. He believed the majority's decision actually relaxed that standard, sort of watered it down.
Which raises an important question for Alito then. What's the real danger, from his perspective, of allowing universities this much discretion to define critical mass without clearer metrics?
He saw it as opening the door to racial preferences without sufficient accountability, potentially undermining the very principle of equal protection that the 14th Amendment guarantees.
So for Alito, this wasn't a careful application of strict scrutiny at all, but really a lowering of the bar. It just highlights this fundamental disagreement within the court itself about what equal protection truly means in practice, doesn't it?
Absolutely. And if we connect this to the bigger picture, this whole deep dive really illustrates that profound disagreement. How far can universities go to achieve diversity? What does equal protection demand? It's a testament, really, to the idea that there's always more to learn and multiple perspectives truly enrich understanding.
It certainly is. And it's also a great example of that fascinating interplay of policies we talked about, how the top 10% plan, meant to be race-neutral after Hopwood,
Interacts with the holistic review where race is a factor for the others.
exactly. This complex dance of policies was so central to the whole debate and the final outcome.
And why you should care about all this is, well, pretty straightforward. This ruling and the really robust arguments surrounding it, they continue to shape admissions policies across public universities nationwide.
It directly impacts how future generations gain access to higher education.
Totally. It really highlights that incredibly tricky balancing act between individual rights and broader societal goals. It shows how the actual paths to opportunity are shaped by these legal battles.
Well, we've certainly journeyed through a highly complex legal landscape today. From the historical roots of affirmative action all the way to the intricate arguments in Fisher v. University of Texas at Austin II.
We've seen how Justice Kennedy's majority opinion affirmed UT's approach as constitutional under strict scrutiny.
While Justice Alito's dissent powerfully challenged its necessity and its constitutionality.
It's really a testament to the enduring complexity and, frankly, the evolving nature of these issues in American law.
Indeed. And maybe for a final provocative thought for you to ponder. Given all these detailed arguments about critical mass, about the effectiveness of race-neutral policies, the nuanced application of holistic review, how might future legal and educational landscapes evolve? How will they define or demonstrate a university's compelling interest in diversity in ways that satisfy all constitutional challenges? As these questions continue to evolve, what does it mean for the future of fairness and opportunity in higher education?
Keep exploring these complex issues. Understanding diverse viewpoints, like we discussed today, is truly key to real knowledge.
Thank you for joining us on this deep dive. We'll see you next time.